This is the story of Paul R. Hansmeier, an illegal copyright troll who was sentenced to 14 years in federal prison for his role extorting millions of dollars from online file sharers, pirates. This is a community-supported legal education channel. Find out how you can support our mission at the links in the description below. Naturally, Paul Hansmeier of Prenda Law did not want to spend 14 years in prison for his role in an illegal copyright trolling extortion scheme, so he appealed his sentence to the 8th Circuit Court of Appeals, and he has now lost. Let's see what the judge, who does a great job of summarizing this, has to say. Paul Hansmeier was charged in an 18-count indictment with mail and wire fraud, conspiracy to commit mail and wire fraud, conspiracy to commit money laundering, and conspiracy to commit and suborn perjury. After the district court denied his motion to dismiss the 17 fraud and money laundering counts, Hansmeier pled guilty to 1 count of conspiracy to commit mail and wire fraud and 1 count of conspiracy to commit money laundering. He was sentenced to 168 months or 14 years imprisonment and ordered to pay restitution in the amount of approximately $1.5 million. Paul Hansmeier was an attorney licensed to practice law in Minnesota. Along with his business partner John Steele, who was charged in the same indictment, Hansmeier operated the law firm Steele Hansmeier PLLC. Beginning around September of 2010, the firm started representing organizations and individuals that owned the copyrights to certain movies. As part of their representation, Hansmeier and Steele pursued the following strategy as described in the indictment. Quote, defendants and their agents monitored file-sharing websites and obtained IP addresses of individuals who downloaded or attempted to download their clients' movies. Defendants then filed copyright infringement lawsuits against these anonymous individuals, sometimes referred to as John Does, and sought authority from the court, often referred to as early discovery or expedited discovery, to subpoena internet service providers for subscriber information associated with the IP addresses. After receiving the subscriber information, defendants made phone calls and sent letters to the subscribers associated with the targeted IP addresses in which they threatened overwhelming financial penalties. The copyright statute permits plaintiffs to recover damages of up to $150,000 per infringement and public disclosure of their infringement unless the purported infringers agreed to pay a settlement of approximately $4,000. Many of the individuals who received defendants' letters and phone calls agreed to pay the settlement rather than incur the expenses of defending the lawsuit, which would undoubtedly exceed the settlement amount, or risk being publicly shamed for allegedly downloading the movies. The indictment alleges that Hansmeier and Steele started by monitoring file-sharing websites to look for potential infringers. Beginning in April 2011, however, the two men began directing their agents to upload their clients' movies to BitTorrent file-sharing websites, including a website named The Pirate Bay, in order to entice people to download the movies and make it easier to catch those who attempted to obtain the movies. Once Hansmeier and Steele identified potential infringers who downloaded the movies, they took the same steps of seeking early discovery, sending settlement demands, and receiving payments from alleged infringers. Hansmeier and Steele told neither the courts in which they sought discovery nor the alleged infringers that they were responsible for making the films available on the file-sharing sites. Several months later, Hansmeier and Steele again modified their strategy. First, in November of 2011, they caused Prenda Law to be created. Though the firm was nominally owned, in name only, by their associate, the two men exerted de facto control over it and used the firm to pursue their copyright infringement litigation. The indictment alleges that Hansmeier and Steele, on multiple occasions, falsely denied to various courts any direct involvement with or control over Prenda Law. Next, they created the organizations AF Holdings and Ingenuity 13. Hansmeier and Steele represented to the courts that these organizations were owned and controlled by other individuals and used the names of an acquaintance and of a paralegal they employed. But in reality, Hansmeier and Steele controlled both. Under their direction, these organizations obtained copyrights to a number of films and then served as Hansmeier and Steele's clients as the two men pursued their copyright litigation. Unknown to both the courts and the alleged infringers, Hansmeier and Steele were thus the direct beneficiaries of all settlement payments made out to AF Holdings and Ingenuity 13. This means that Hansmeier and Steele were not just lawyers representing a client and the settlement funds were going to the client minus whatever attorney's fee Hansmeier and Steele were charging, but rather Hansmeier and Steele were both the lawyers representing themselves as clients and not telling anyone that there was no actual client. So they're taking all the money for themselves. Again, without telling anyone that they are the seeders or the source of the file sharing activity. The indictment alleges that, in order to carry out their litigation strategy, Hansmeier and Steele deceived both the courts in which they sought discovery and the alleged infringers they sued. Specifically, the indictment accuses Hansmeier and Steele of deliberately concealing from the courts their role in distributing the movies, as well as their significant personal stake in the outcome of the litigation. This concealment, the indictment alleges, was done with the purpose of gaining access to downloaders' identifying information in order to garner quick settlements from individuals who were unaware of the defendant's role in uploading the movie, who were often either too embarrassed or could not afford to defend themselves. I represented a number of defendants against parental law, and I agree that many defendants were too embarrassed with the threat of being publicly outed as downloading these films, and they were either coerced into paying a settlement because they were embarrassed or they were unable to pay to litigate, and so therefore paid the smaller amount that was asked in settlement. That's sort of the definition of a copyright troll, where we normally look at damages based on actual damage, and therefore the plaintiff must be restored or made whole by the recovery of those damages. A copyright troll doesn't really need that amount of money, doesn't really need major statutory damages because the damage really isn't that high. So they can just charge whatever they want, and whatever the market will bear, whatever the defendant will pay, which is what makes it pretty horrible. And the other problem I see is I don't see Congress updating this law. Congress usually favors plaintiffs or copyright owners when making copyright law adjustments. I don't see that Congress is going to suddenly say $750 minimum per title for basic online file sharing is too much. I have a feeling that if the courts can't do anything because their hands are tied, then I don't think anything's going to change. Accordingly, the indictment claims any representations Hansmeier and Steele made to the courts or the alleged infringers that they and their clients had legitimate copyright infringement claims or had suffered damages from that infringement were also false. Around October 2012, after courts had begun limiting the discovery they could obtain through copyright infringement suits, Hansmeier and Steele developed a new way to seek copyright settlements. This involved the creation of 3 new organizations: Guava, Livewire Holdings, and LW Systems. As with AF Holdings and Ingenuity 13, though Hansmeier and Steele represented that those companies were owned by other individuals, Hansmeier and Steele actually controlled each company. Under their new strategy, Hansmeier and Steele filed lawsuits alleging that certain John Does had hacked these companies' computer systems. This, the indictment claims, was a lie. While the John Does in question had apparently downloaded the films, they had not hacked into any computer systems. Indeed, the companies had no computer systems to hack. In reality, according to the indictment, Hansmeier and Steele brought these lawsuits in a renewed attempt to learn the identities of alleged infringers and to send them settlement demands. In this effort, Hansmeier and Steele recruited ruse defendants. These defendants were people Hansmeier and Steele had caught downloading movies for which they, or their purported clients, possessed copyrights, in exchange for Hansmeier and Steele waiving their copyright claims against them, or dropping the claims. The ruse defendants agreed to be sued for hacking the company's computer systems. This then allowed the two men to seek discovery about the ruse defendants' alleged co-conspirators in the computer hacking. In reality, these co-conspirators were just other downloaders of copyrighted movies whose IP addresses Hansmeier and Steele identified through the file-sharing sites. Once Hansmeier and Steele gained subpoena authority for the supposed co-conspirators' information, they sent them the same copyright-based settlement demands described above. Eventually, courts grew suspicious of Hansmeier and Steele's litigation techniques and started denying their subpoena requests, dismissing their lawsuits, imposing sanctions, and notifying state attorney disciplinary bodies and other courts. The indictment includes language from a federal district court order imposing sanctions against both men, in which the court states that the two have demonstrated their willingness to deceive not just this court, but other courts where they have appeared, and that their deception was calculated so that the court would grant their early discovery requests, thereby allowing them to identify alleged copyright infringers and extract settlement proceeds from them. The responses from the courts effectively ended Hansmeier and Steele's operation. But between 2011 and 2013, before they faced this increased scrutiny, Hansmeier, Steele, and their entities received more than $6 million in copyright settlement payments, half of which went to Hansmeier and Steele themselves. On December 14, 2016, a federal grand jury charged Hansmeier and Steele with conspiracy to commit wire and mail fraud, multiple instances of mail and wire fraud between December 11th and April 2013, conspiracy to commit money laundering, and conspiracy to commit et suborn perjury. Hansmeier moved to dismiss all but the perjury count, arguing that the facts alleged did not constitute criminal fraud. The magistrate judge recommended the motion be denied, and the district court adopted the recommendation. Following the district court's order, Hansmeier entered into a conditional plea agreement with the government, pleading guilty to 1 count of conspiracy to commit mail and wire fraud and 1 count of conspiracy to commit money laundering, reserving the right to appeal the denial of his motion to dismiss. At sentencing, the district court heard evidence about restitution. In support of its proposed restitution amount, the government called Jared Carey, a special agent with the FBI. Agent Carey described Hansmeier and Steele's settlement strategy, explaining that the settlements their targets agreed to pay typically ranged between $2,500 and $3,400, though were sometimes lower. Based on his review of Hansmeier and Steele's financial documents, Agent Carey estimated that, between 2010 and 2013, the alleged infringers Hansmeier and Steele targeted paid over $6 million total in settlements. Agent Carey then summarized a spreadsheet the FBI created to estimate the proper restitution amount. The spreadsheet did not include all of the settlement money that came in over this time period. Rather, it was limited to payments made after April 2011, which is when there was evidence that Hansmeier and Steele posted to file-sharing websites a movie to which they held the copyright. In other words, when, under the government's theory, their fraud scheme began, and to payments that he could link to specific victims. Based on these parameters, he calculated a restitution figure of $1.5 million. Hansmeier objected to this calculation on the basis that the FBI's spreadsheet did not distinguish between settlement payments that came from legitimate lawsuits and those that came from fraudulent ones. The court found the defense's arguments unconvincing, noting there does not appear from the testimony and from the facts admitted at the plea any more than potentially a negligible amount of what could be reasonably considered money coming from a source other than the overall fraudulent scheme, and so this is a pretty conservative restitution amount. The court ultimately accepted the government's evidence and imposed restitution in the amount of $1.5 million. Hansmeier now appeals. We, the Eighth Circuit, review de novo, or brand new, a defendant's motion to dismiss an indictment for failure to state an offense. In doing so, we accept the allegations stated in the indictment as true and ask whether they can form the basis of the charged offense. A slightly greater level of detail is required for bank, mail, or wire fraud, for which an indictment must specify facts with such reasonable particularity as will apprise the defendant with reasonable certainty of the nature of the accusation, and as will enable the court to say that the facts stated are sufficient in law to support a conviction. This is the requirement that fraud be pled with particularity. We have a video on that here. The question of whether the facts alleged in an indictment adequately state an offense, therefore, turns on the elements of that offense. The mail and wire fraud statutes at issue here prohibit the use of interstate mail or wire facilities to effect any scheme or artifice to defraud, or for obtaining money or property by means of false or fraudulent pretenses, representations, or promises. As Hansmeier notes, the term scheme to defraud initially may seem slightly amorphous. A scheme to defraud is defined as a departure from fundamental honesty, moral uprightness, or fair play and candid dealings in the general life of the community. But cases from this circuit and the Supreme Court have offered more concrete guidance on what the mail-and-wire fraud statutes require. To prove the existence of a fraudulent scheme, the government must establish 1. There was a deliberate plan of action or course of conduct to hide or misrepresent information, 2. The hidden or misrepresented information was material, and 3. The purpose was to get someone else to act on it. As this definition indicates, for criminal liability to attach, a scheme to defraud must consist of material misrepresentations, misrepresentations that have a natural tendency to influence or are capable of influencing the decision of the decision-making body to which they are addressed. To defraud someone requires material, affirmative misrepresentations, or active concealment of material information for the purpose of inducing action. However, a scheme to defraud need not involve affirmative lies. While non-disclosure of a relevant fact characterized by mere silence is not enough for fraud, active concealment, deceptive acts or contrivances intended to hide information, mislead, avoid suspicion, or prevent further inquiry into a material matter can form the basis of a fraudulent scheme. Finally, though fraud necessarily involves misrepresentations made with the object of obtaining money or property from victims, it is not the case that the victims targeted must be the direct recipients of the materially deceptive statement or concealment. Rather, we have held that the misrepresentations may be made to third parties, where the third parties are used to further the scheme to defraud the ultimate victims. Hansmeier's indictment identifies 2 related litigation strategies that Hansmeier and Steele employed between late 2011 and 2013, and that form the basis of the government's fraud allegation. Both meet the elements of a fraudulent scheme. In the first, Hansmeier and Steele brought copyright infringement lawsuits and requested discovery on behalf of their supposed clients, seeking the identities of alleged copyright infringers, but did not disclose, 1, that they directed agents to make the copyrighted works available on websites known for illegal downloading, and 2, that the clients were in fact companies that Hansmeier and Steele set up in order to personally profit from anticipated settlements. On its face, this alleged conduct meets the elements required for a fraudulent scheme. By posting the movies, Hansmeier and Steele took steps to ensure that they would have a pool of potential copyright infringers to target through litigation. And by having separate companies that they controlled act as their clients, they obscured their potential and financial involvement in those lawsuits. Hansmeier and Steele's choice to conceal from the courts their full involvement in the lawsuits thus constitutes a deliberate plan of action to hide or misrepresent information. The information they misrepresented was also material. Had the courts known that Hansmeier and Steele intentionally posted the films on websites used for illegal file sharing, or that the 2 men were in fact the personal beneficiaries of their clients' copyright claims, they would have treated the subpoena requests with far greater skepticism. Indeed, the indictment alleges that Hansmeier and Steele faced dismissals of their lawsuits and sanctions when the extent of their involvement eventually came to light. That Hansmeier and Steele created multiple organizations under the names of their associates in order to pursue litigation rather than naming themselves as the copyright holders itself suggests that they knew how relevant the courts would find this information. And the court's skepticism about Hansmeier and Steele's level of personal involvement and financial interest in the litigation would have been likely even if, as Hansmeier argues, their claims did involve actionable copyright infringement. Finally, the indictment makes clear that the purpose of Hansmeier and Steele's concealment was to induce the courts to act in the form of granting their subpoena requests, and the ultimate object of those requests and the deceptive tactics leading up to them was to obtain settlement payments from a pool of alleged infringers. Putting the different elements together, the indictment alleges that Hansmeier and Steele, 1, developed and executed a plan that depended on them, 2, deliberately concealing material information from the courts, 3, with the purpose of convincing those courts to grant their discovery requests, and 4, with the ultimate object of obtaining settlement payments from alleged infringers they identified through those discovery requests. This conduct meets the elements of criminal fraud. The second litigation strategy utilized by Hansmeier and Steele, which began in the fall of 2012, shared many features of the first, including the use of discovery to obtain identifying information for alleged infringers and the deployment of that information to then obtain settlement payments. While the second approach similarly involved misleading courts by concealing material information in order to subpoena downloaders identifying information, Hansmeier and Steele also began actively lying to the courts. As the indictment describes, the two men falsely accused a number of ruse defendants of hacking into their clients' systems and, through these false accusations, convinced the courts to provide them with the requested discovery. Thus, and for some of the reasons outlined above, the indictment's presentation of Hansmeier and Steele's conduct involving ruse defendants is sufficient to support fraud charges. The only difference is that the deception there came in the form of affirmative misrepresentations. In sum, the conduct recounted in the indictment constitutes a scheme for obtaining money or property by means of false or fraudulent pretenses, representations, or promises. Taking its allegations as true, the indictment lays out a sufficient basis for the government's charge that Hansmeier committed fraud, and it informs the court and the parties involved of the facts underlying that charge. This is what is legally required of an indictment. In his defense, Hansmeier was free to dispute the facts, offer alternative explanations for his conduct, or provide context to any of these actions alleged. In short, it was Hansmeier's right to present any lawful defense available to him against the government's effort to prove his guilt beyond a reasonable doubt. But Hansmeier's possible defenses are not relevant to our consideration of whether the indictment itself properly stated the basis for the charged offenses. Because the facts in the indictment, accepted as true, described a fraudulent scheme prohibited by federal law, Hansmeier cannot succeed in his claim that it is facially insufficient. We affirm the district court's denial of his motion to dismiss. Disputing this conclusion, Hansmeier invokes the metaphor of a three-legged stool, arguing that because none of the independent legs viewed on its own involves him lying to or concealing information from his ultimate victims, the theory of fraud laid out in the indictment fails. Even assuming this characterization of his conduct is accurate, there is no authority suggesting that courts should approach fraud charges in this fragmented manner. Indeed, such an approach would risk allowing more sophisticated fraudulent schemes, which may involve multiple independently legal acts or falsehoods aimed at providing the perpetrators with legal or regulatory authority to pursue their victims to go unchecked. Hansmeier also argues that the district court's award of $1.5 million in restitution violated the Mandatory Victims Restitution Act. Specifically, he claims that the district court erred in relying on a calculation that included not just losses by victims of the fraud scheme, but also legitimate settlement payments from the same period, i.e., those paid by people who downloaded copyright-protected movies posted on file-sharing websites by people other than Steele and Hansmeier. The government first responds that Hansmeier waived any right to challenge the application of the MVRA in the terms of his plea deal. The agreement specifies, "Defendant understands and agrees that the Mandatory Restitution Act applies, and that the court is required to order the defendant to pay the maximum restitution to the victims of his crimes as provided by law. The defendant understands and agrees that the court will order him to make restitution for the entire loss caused by his fraud scheme, and that the restitution order will not be limited to the counts of conviction." We do not read this provision as a waiver of Hansmeier's right to appeal the restitution award, nor is it a pledge to pay the $3 million in fraudulent proceeds identified elsewhere in the agreement. Unlike in the cases on which the government relies, Hansmeier did not agree to pay any restitution ordered by the district court, or agree to pay restitution up to a certain amount. Here, Hansmeier simply agreed that the MVRA would apply and the court would order him to pay restitution. He did not, in doing so, waive his right to challenge any perceived error in the ultimate restitution amount imposed. Because Hansmeier did not waive the issue, we will review the district court's decision to award restitution for an abuse of discretion, and the district court's finding as to the amount of loss for clear error. Abuse of discretion and clear error are different standards of review, standards of appellate review. The MVRA requires that sentencing courts order restitution in all cases where an identifiable victim or victims has suffered a physical injury or pecuniary or monetary loss as a result of the commission of an offense. Restitution must be based on the amount of loss actually caused by the defendant's offense, and the burden is on the government to prove that the restitution awarded does not exceed the actual provable loss caused by the offense. In fraud cases, restitution may be ordered for criminal conduct that is part of a broad scheme to defraud, without regard to whether the defendant is convicted for each fraudulent act in the scheme. However, the actual loss requirement means that courts must be wary of over-inclusiveness, and particularly of setting payment amounts that encompass both losses caused by the fraud at issue and legitimate payments separate from the fraudulent scheme. Here, the government met its burden of showing by a preponderance of the evidence that the $1.5 million loss total was attributable solely to settlement payments from the fraud scheme. The figure was based on calculations Agent Carey presented to the court at the sentencing hearing. In coming to his final loss amount, Agent Carey included only settlement payments from April 2011 on, when Hansmeier and Steele directed an associate to upload a movie, which they held the copyright to and which they used in their fraudulent lawsuits, uploaded to file-sharing websites. Agent Carey explained that the movie became the go-to movie as far as gaining settlements from individuals. He said that other movies were not a significant source of profit from that point on, constituting just a few payments trickling in here or there. Considering this information, the district court characterized potential payments from legitimate lawsuits over this period as making up no more than a potentially negligible amount of money Hansmeier and Steele received. Agent Carey further attempted to narrow his calculation to payments from fraud victims by excluding any payments that came in over this period that he could not tie to a specific person, suggesting that his estimate might in fact have been under-inclusive of the total amount Hansmeier and Steele received from their fraud scheme. Agent Carey also showed his list of identified victims to Steele, who confirmed that only 1 or 2 names were not those of fraud schemes. Finally, Hansmeier himself acknowledged in his plea agreement that between 2011 and 2014, he and Steele received more than $3 million in fraudulent proceeds from their lawsuits. In light of the information the government presented at sentencing, the district court did not clearly err in concluding that the $1.5 million figure was fairly representative of the actual loss caused by the fraudulent scheme. We affirm the judgment of the district court. And that's probably the conclusion of Paul R. Hansmeier's appeals of his 14-year conviction for a fraudulent copyright trolling scheme. To fill in some details that the court didn't give you, they created some of their own movies that were targeted to people over the age of 18. I'm trying to avoid triggering the YouTube censors. And they then uploaded those movies to file sharing websites like the Pirate Bay in order to generate more file sharing activity on which they could then file these fraudulent lawsuits. At one point, I believe it was John Steele's gardener, I think his name was Alan Cooper, was asked to sign something and he didn't know what he was signing, and either he signed a different page because it was presented to him in one way and he signed the page, and he didn't realize he was signing a fake copyright assignment so that it would appear that John Steele and Paul Hansmeier were not actually the copyright owners, but rather somebody else named Alan Cooper. When eventually Alan Cooper had to testify in court, he had absolutely no idea that he was on some fake copyright assignment document. And then regarding the computer hacking allegations, that's through a civil claim under the Computer Fraud and Abuse Act, which does allow plaintiffs to go after defendants who have hacked into computer systems. And so what Prenda Law and Paul Hansmeier would do is find a victim who would roll on the other defendants in a file sharing swarm, and then get that victim to sign court papers saying that he was actually guilty of hacking, and that in return for waiving the punishment, the penalties under copyright and the Computer Fraud and Abuse Act, that he would admit to this scheme, which was really not a scheme at all, just a swarm of file sharers, and then get a court to approve subpoenas to thousands of participants in the file sharing swarm, thereby giving Hansmeier and Steele and Prenda Law even more victims to go after in their fraudulent scheme. So that was quite a time of my life as well. I was a brand new attorney just starting to defend people from file sharing lawsuits. I wanted to be a copyright attorney, but how do you be a copyright attorney in Pennsylvania was the thought at the time. Well, Pennsylvania was one of the targets of John Steele and Paul Hansmeier in their Prenda Law copyright trolling scheme. I remember being on the phone with Paul Hansmeier one time, and I asked him for a copy of a subpoena because the subpoena came from a different court, and I didn't think that that court had jurisdiction over my client in a different state. So I asked him for a copy of the subpoena, and he told me to F off. So that was also a very interesting time as a brand new attorney to experience the aggression that was coming from Hansmeier and Steele as well. Eventually, some of my clients did settle their cases, and I did counsel those clients to seek restitution from the, I think, Minnesota Attorney General from these charges. I'm not sure if anyone actually ever did. But that's the story of how Paul Hansmeier ended up in prison for 14 years. If I have my information correctly, I think that he will serve 85% of that time if he is a good prisoner, if for good behavior. So let me know what you think in the comments below. This is very similar to what's happening with other copyright trolls, except for the key detail that other copyright plaintiffs, who I'm not going to name and associate with this, but other copyright plaintiffs actually do purport to represent actual copyright owners separately and not themselves. In other words, Hansmeier and Steele were attorneys that were telling the courts that they were representing these corporate defendants, but Hansmeier and Steele were actually the corporate defendants themselves. They made those corporations and then represented to the courts that they did not own those corporations when they really did. And then they funneled approximately $3 million to themselves. And then they only have to pay $1.5 million of it back, or at least Paul Hansmeier only has to pay $1.5 million of it back. I imagine he still made some decent money off the copyright trolling scheme, which is kind of sad that in exchange for 14 years of his life, he probably still has at least several $100,000, or at least had access to several $100,000, maybe even $1 million or more from that scheme. Anyway, let me know what you think in the comments below. Thank you for watching. I'm Leonard French, your favorite copyright attorney, and this is Lawful Masses, your favorite legal news and education channel here on YouTube. You can also find us on Floatplane and on twitch.tv/lawfulmasses on Sunday mornings at 10 a.m. Our channel is community supported by your monthly financial contributions on patreon.com/ljfrench, sponsors.com/law, through YouTube memberships, and through Floatplane subscriptions. Thank you to the following $50 plus supporters in the month of February: Joe Tyson, John Steele, Gavin Barnard, Kyle Mudrak, Eevi, Spirit Bear, Andy, Benjamin Hitov, Ugly Grill, Shielo T, Rudolph Bescherer Jr., Oscar the Phrophet, Brandyn Abel, Torpedan, Sovereign Tittizen, ShadowTycho, Earthbound Star, RDHDragon, Nathan McCarty, and Winter Grill. And thank you as well to the $5 plus supporters who are scrolling on your screen. I hope everyone has a great week. I will see you in the videos that drop. I love you all. Bye.
I'm not a cat.